Imagine this. A business looks totally legit, handles huge sums of money, but underneath, it's maybe funneling cash from drug deals or worse, funding terrorism, or even weapons of mass destruction. Sounds dramatic, I know, but it's a real threat. It undermines everything, destabilizes markets, empowers some really dangerous people, silently. Which brings us to today's deep dive. We're unpacking a really critical piece of law, often mentioned but maybe not fully understood, the Financial Intelligence Center Act 38 of 2001. You probably know it as FICA. Yeah, FICA. So our mission today, we want to give you a really solid handle on it. What's its main job? How does it work day to day? Where did it come from legally? And, what does it actually mean for businesses and for you?
Absolutely. We'll aim for clarity, mixing plain language with the necessary legal bits, maybe some examples to make it stick. Whether you're just curious or maybe studying law, this should help.
Good, because it seems complex.
It can be. What's really key to grasp is that FICA isn't some old law-gathering dust. Think of it more like a constantly updated shield.
So it changes often.
Oh, definitely. We looked at the sources, and they were checking for updates as recently as October 2024. The last big changes went in around August 2023.
Wow. Okay, so it's actively evolving.
Exactly. It has to. It reflects this ongoing, intense battle against financial criminals who are, frankly, always getting more sophisticated, always probing for weaknesses.
Right, makes sense. Okay, let's step back then. Why FICA? What specific big threats was it created to fight?
Well, at its core, FICA targets, let's say, three main kinds of bad financial activity. First, the one we probably hear about most, money laundering.
Making dirty money look clean.
Precisely. The Act defines it quite specifically, concealing or disguising the origin, the source, the location, how the proceeds of crime are moved around.
Proceeds of crime. So money from illegal stuff.
Yep, drug money, theft, fraud, you name it. Getting that cash into the legitimate system so it looks like it came from a normal business, that's laundering.
Okay, that's number one. What else?
Second, FICA aims squarely at the financing of terrorist and related activities. This is crucial. It's about cutting off the funds that allow these groups to operate and cause harm. It's a direct national security issue.
And international security too, I imagine.
Absolutely. And third, this is a slightly newer focus, but just as critical, is proliferation financing.
Proliferation, like spreading weapons.
Exactly. Providing money, services, economic support for developing or acquiring nuclear, chemical, or biological weapons. Basically, stopping WMDs by cutting off the cash flow.
Okay, that's a heavy list. Money laundering, terror financing, proliferation financing. So how do we fight that? FICA set up the Financial Intelligence Center, the FIC.
That's right, the FIC. Think of it as the central hub, the nerve center for financial intelligence in the country. It's designed as an independent body.
Independent, okay.
Yep.
Not just another government department.
Correct. It's outside the public service, but operates within public administration. Its main job is, well, like being a financial detective agency for the whole country. Identifying dirty money, identifying the people involved in laundering, terror financing, proliferation.
So they find the connections, piece together the puzzle.
That's a good way to put it. But it's not just identifying, it's also about combating these things.
Which means working with others, I guess.
Hugely important. The FIC implements financial sanctions, the ones handed down by the UN Security Council, for example. And critically, it shares intelligence.
Shares it with who?
With a whole range of authorities. The National Prosecuting Authority, SARS, intelligence agencies, even the Public Protector. They get the financial picture, and these bodies can then investigate, prosecute, collect revenue, whatever's needed.
Makes sense. Information needs to lead to action.
Definitely. And they share info internationally, too, with similar bodies in other countries. Yeah. Because this fight doesn't stop at the border. Oh, and a newer, really vital role is producing actual forensic evidence, mapping out transaction flows, linking people to assets.
So providing the proof needed for court cases.
Essentially, yes.
Okay.
Okay, so when did all this start? You mentioned the act is from 2001.
Right. It was signed into law late 2001, but it didn't all happen at once.
So a gradual rollout.
Exactly. Different parts were switched on, so to speak, between early 2002 and, believe it or not, right up to February 2023.
That's quite a long phasing in period.
It is, and I think it shows how complex it was to get everything up and running for the institutions that had to comply and for the FIC itself.
And you said it keeps changing. Amendments.
Constantly adapting. Over the years, there have been some major amendments. Things like the laws dealing specifically with terrorism financing, specific FICA Amendment Acts, even links to the Cybercrimes Act recently. The big Anti-Money Laundering and Combating Terrorism Financing Amendment Act also brought significant changes.
So it's always playing catch-up, or trying to stay ahead of the curve?
I think that's the reality, yes. Keeping pace with new threats, meeting international standards, it's a dynamic field.
And legally, how does FICA stack up against other laws if there's a conflict?
Good question. Section 1A is pretty clear. FICA generally takes precedence. If another law clashes with FICA on something FICA covers, FICA wins out.
Except for the Constitution, presumably.
Ah, yes, the Constitution is always supreme. But otherwise, FICA's rules are paramount in its domain, which really underlines its importance.
Okay, so we have the why, the big threats, and the when, its evolution. Let's get into the how. How does FICA actually work on the ground? Who exactly has to follow these rules, these accountable institutions?
Right, the front lines. So accountable institutions, think of businesses that are, well, most likely to be targeted or used by criminals.
Like banks.
Banks are the obvious one, yes, but also attorneys, estate agents, casinos, and other gambling spots, long-term insurers, financial advisors, anyone dealing in foreign exchange. Schedule 1 lists them all. It's quite broad. These guys have the most significant FICA duties.
Okay. And you also mentioned reporting institutions.
Yeah, that's a slightly different category with fewer obligations, but still important. Think motor vehicle dealers or people dealing in Kruger Rands. They're listed in Schedule 3.
And who keeps an eye on all these institutions, make sure they're doing what they should?
Those are the supervisory bodies, like the Financial Sector Conduct Authority, the FSCA, for many financial institutions, or the South African Reserve Bank for banks. They're the watchdogs.
Got it. So if I walk into a bank or deal with an estate agent, what should I expect because of FICA? It sounds like this customer due diligence CDD is key. Knowing your client.
It's absolutely fundamental, the bedrock, really. Section 20A states it plainly. No anonymous clients, no accounts opened in false or made-up names, full stop.
No hiding. Make sense?
And it's not just about showing your ID card, is it?
Oh, much more than that. For any new relationship or transaction, they must establish and verify your identity. Get proof.
And if I'm acting for someone else, like for a company or a trust?
Then they need to check both. Verify your identity and verify the identity of the person or entity you represent, and verify that you actually have the authority to act for them.
Okay, that's thorough. What about existing clients, people who had accounts before FICA really kicked in?
Doesn't matter. The law required institutions to go back and verify the identities of those existing clients too, so everyone gets covered eventually.
But you said it goes deeper than just ID.
Yes. Section 21A. It's about understanding the relationship. What's the nature of it? What's the intended purpose? Why are you doing this business with them? And critically, where are the funds coming from? The source of funds.
Why the source of funds?
It helps build a picture, a profile of expected activity. So if suddenly a huge unexplained amount comes in later, it stands out against that initial understanding. It raises a flag.
Okay. Now this sounds really crucial. Beneficial ownership. Peeling back the layers to find the real person in charge.
Exactly. Section 21B. This is a huge focus globally now. A beneficial owner is the natural person, the actual human being, who ultimately owns or controls a client, like a company or a trust, or who ultimately controls a specific transaction.
So no hiding behind complicated company structures.
That's the goal. For companies, partnerships, trusts, institutions have to dig deep. Identify every single natural person who has a controlling ownership stake, or who exercises control through other means, or who manages the entity. It's about piercing that corporate veil that criminals love to use.
And this isn't just a one-off check when you open the account, right? You mentioned ongoing monitoring.
Correct. Section 21C, ongoing due diligence. It's continuous vigilance. Institutions have to keep monitoring transactions throughout the relationship.
Looking for what, specifically?
Consistency, mainly. Do the transactions still make sense based on what they know about the client? Does the source of funds still align with the client's profile? They're specifically tasked with examining complex transactions, unusually large ones, or any transaction that seems to have no obvious business or legal reason behind it.
Spotting the odd ones out.
Basically, yes.
Yeah.
Spotting anomalies that might indicate something illicit is going on.
So what if the bank or the attorney has doubts? They get some information, but it feels off, or they just can't complete these checks for some reason?
FICA is very clear on this, sections 21D and 21E. If they doubt the info or can't verify it properly, they must try again, re-verify.
And if they still can't?
Then they are prohibited from starting the business relationship or processing the transaction. They literally have to refuse the business. Importantly, they should then consider filing a suspicious transaction report with the FEC.
Okay, refuse and report. Now let's talk about PPPs, politically exposed persons. We hear this term a lot. Who are they and why the extra scrutiny?
Right, PPs. This is about managing the higher risk potentially associated with people in positions of public power or influence. FICA defines different categories.
So that's it.
You've got foreign politically exposed persons, think heads of state, senior politicians, top judges, high-ranking military officials from other countries. Schedule 3B lists examples.
Okay, foreign leaders.
Then domestic politically exposed persons, people holding prominent public functions here in South Africa. The president, deputy president, ministers, deputies, members of parliament, judges, municipal managers. Again, Schedule 3A gives details.
Right, local officials and politicians.
And a third category, prominent influential persons. This can include, for instance, chairpersons, CEOs, CFOs of companies that have significant business dealings, like supplying goods or services above a certain value with organs of state. That's Schedule 3C.
So senior business figures linked to state contracts too. Why all the fuss about them?
It's about risk. These positions, unfortunately, can sometimes be vulnerable to corruption, bribery, or being used to launder money. So FICA mandates enhanced due diligence for PPs.
Enhanced meaning what exactly?
It means extra steps. Institutions need approval from their own senior management before establishing a relationship with the P. They have to take reasonable measures to establish the source of the PP's wealth and the source of the specific funds involved in transactions. And crucially, they must conduct more intensive, ongoing monitoring of the business relationship.
So keeping a closer eye on their financial activity.
Yes. And this scrutiny isn't just limited to the PP themselves. It extends to their immediate family members, spouse, children, parents, siblings, and also to any known close associates.
Why family and associates?
Because, well, illicit funds or influence can often flow through these close connections. It closes potential loopholes.
Makes sense. Okay, so institutions are identifying people, understanding beneficial owners, monitoring transactions, paying special attention to PPs. What about the paperwork? The record keeping.
Absolutely vital. If you don't have records, you can't prove anything later. Institutions must keep detailed records of all the CDB information copies of ID documents, details about the business relationship itself, and, crucially, transaction records.
What needs to be in a transaction record?
Enough detail to reconstruct it. The amount, the date, who the parties were, the nature of the transaction, any related correspondence, account details involved.
And how long do they need to keep all this?
The rule is generally at least 5 years. That's 5 years after the business relationship is terminated, or 5 years after a specific transaction is concluded, or if a suspicious transaction report was filed about it, 5 years from the date of that report.
5 years. Can they keep it electronically?
Yes, electronic records are fine, provided they can be easily accessed and reproduced in a usable format. And even if they use the third party for storage, the accountable institution itself remains legally responsible for ensuring those records are kept properly.
And these records can be used in court?
Yes. FICA specifically states that these records are admissible as evidence. They form the paper trail.
Okay, so they've got the info, they're keeping records. When do they actually have to raise a flag and tell the FIC something? What are the reporting duties?
This is where the intelligence actually flows to the FIC. There are several triggers. First, a simple one, Section 27. If an authorized FIC representative asks an institution, is Mr. X or Mrs. Y a client, or have they been? The institution must answer truthfully.
Okay, responding to direct inquiries. What else?
Then there are specific transaction reports. Section 28 deals with cash transactions above a certain limit. This is a very common one, reporting large movements of physical cash.
Because large cash sums can be suspicious in themselves.
Yes, or at least warrant scrutiny. Then Section 28A covers reporting any property they hold that's known or suspected to be linked to terrorist activities or entities subject to financial sanctions under UN resolutions.
Cutting off terrorist assets. Got it.
And then the big one, Section 29, suspicious and unusual transactions. This is arguably the most critical reporting duty.
What makes a transaction suspicious or unusual?
The triggers are quite broad. If anyone involved in a business, not just management, could be an employee knows, or even just reasonably suspects, that they've received or are about to receive proceeds of unlawful activities, or that a transaction relates to terrorist financing, or that a transaction seems designed to avoid FICA reporting duties.
Like breaking up a large amount into smaller ones.
Exactly. That's called structuring, and it's a definite trigger. Or if they suspect tax evasion, or that the transaction is facilitating it, or if it might be contravening financial sanctions, basically anything that smells fishy and might be linked to crime or avoiding the law.
Who has to report this? Just the compliance officer?
No, the duty falls on any person who carries on, manages, or is employed by a business. If you see it or suspect it in your work, you have a duty. Usually this is channeled through internal processes to a compliance officer who then reports to the FIC, but the legal duty is broad.
That seems like a lot of pressure on individuals. Are they protected if they report?
Yes, crucially. Section 38 provides protection for reporters. If you report in good faith, you can't face civil or criminal action for doing so. Your identity is also protected in any resulting court proceedings unless you actually testify. This is vital to encourage reporting without fear of reprisal.
Good. What about tipping someone off, telling the client, hey, we just reported you?
Absolutely forbidden. Section 53 makes unauthorized disclosure tipping off a serious offense. It carries heavy penalties. Secrecy is essential for investigations to work.
Okay, so cash reports, suspicious reports. Any others?
Yes, a couple more key ones. Section 30 covers the conveyance of cash or bearer negotiable instruments across borders. If you physically carry large amounts over the border, you may have to report it on demand.
Trying to stop cash smuggling.
Precisely. And Section 31 deals with large electronic transfers of money into or out of South Africa. Banks have to report these international wire transfers above a certain threshold to the FIC.
So lots of data flowing to the FIC. How do these reports actually get made?
Section 32 says they must be made in the prescribed manner, usually electronically, through secure channels. And the FIC can always ask for more information if a report needs clarification.
If a suspicious transaction is reported, does everything just freeze? Does the transaction stop?
Not automatically, no.
Right.
Section 33 says transactions can usually proceed even after a report is filed. The idea is not to paralyze business unnecessarily or tip off the client prematurely.
But can the FIC step in?
Yes, they can. Under Section 34, intervention by center, if the FIC has reasonable grounds to suspect illicit activity based on a report, they can direct the institution to hold the transaction.
For how long?
For up to 10 days. This gives the FIC a window to make urgent inquiries, analyze the situation, and potentially refer it to law enforcement or another relevant authority before the funds disappear.
A temporary freeze to investigate.
Exactly. And beyond that, there's Section 35, monitoring orders. If there are reasonable grounds to suspect someone is involved in financial crime, the FIC can apply to a judge for an order.
What kind of order?
An order compelling an institution to report all transactions conducted by a specific person or through a specific account to the FIC for a set period, usually up to 3 months, though it can be renewed. This allows for much deeper scrutiny under judicial oversight.
Okay, so the rules are there, the reporting happens, but how do we ensure institutions actually do all this? Compliance and enforcement must be a big part of FICA.
Huge. And it starts with internal systems. Section 42 mandates that every accountable institution must develop, document, maintain, and implement a risk management and compliance program, an RMCP.
What's that involve?
It's basically their internal FICA rulebook and strategy. It has to cover how they identify and assess their specific risks related to money laundering, terrorist financing, and proliferation financing. It must detail their processes for customer due diligence, ongoing monitoring, how they examine complex or unusual transactions, how they handle doubts when they terminate relationships, how they identify PPs, their record-keeping procedures, their reporting mechanisms, everything.
So a comprehensive plan.
Yes, and it needs to be approved by the board or senior management, and regularly reviewed and updated. It also needs to cover how they implement FICA in any foreign branches or subsidiaries they might have.
And someone has to be in charge of this.
Section 42A deals with governance. The board or senior management is ultimately responsible for ensuring compliance, and they typically have to appoint a suitably skilled person to manage the compliance function.
And staff need to know what to do.
Absolutely. Section 43 mandates ongoing training for employees. Everyone needs to understand FICA, the institution's RMCP, and their specific obligations.
Okay, internal programs, training. What else?
Well, simply existing means you need to tell the FIC. Section 43B requires all accountable institutions and reporting institutions, too, to register with the Financial Intelligence Center.
So the FIC knows who it's dealing with.
Exactly. And both the FIC and the supervisory bodies, like the AHART or FSCA, can issue directives under Section 43A. These can instruct institutions on how to apply the Act, tell them to stop doing something non-compliant, or order them to take specific remedial actions.
And if they suspect non-compliance, can they come look?
Oh yes, Section 45B allows for inspections. Authorized inspectors can enter an institution's premises, sometimes needing a warrant, especially for private residences, sometimes not, to check compliance. They can question people, demand documents, examine systems, and seize evidence if necessary.
Okay, so they can check up. What if they find non-compliance? What are the consequences then?
And then we get into administrative sanctions, covered in Section 45C. These are imposed by the FIC or the relevant supervisory body.
For what kind of failures?
Things like failing to identify a client properly, failing to keep records, failing to report a suspicious transaction when they should have, failing to implement their RMCP adequately, not complying with the directive, basically breaches of their FICA duties.
And what form do these sanctions take? A slap on the wrist.
It can range. They consider factors like how serious the breach was, how long it went on, if the institution has a history of non-compliance, and what steps they've taken to fix it. Sanctions can be a formal caution, a reprimand, another directive demanding remedial action, or even restrictions on their business activities, maybe even suspension.
And fines.
Oh yes, significant financial penalties, up to R10 million for an individual, and up to R50 million for a legal entity, like a company.
Wow, 50 million rand, that's serious.
It is. And the authorities can even suspend part of a penalty on certain conditions, or direct that a penalty imposed on a company should actually be paid by the specific individuals within the company who were responsible for the noncompliance.
Holding individuals accountable. Is this a criminal conviction?
No, that's a key distinction. Administrative sanctions are not criminal convictions. However, if criminal charges are later brought based on the same facts, the court must take any administrative sanction into account when deciding on a sentence.
Okay. But are there actual criminal offenses under FICA too? Things that could lead to jail time?
Absolutely. Chapter 4 of the Act details various offenses and penalties.
Like what?
Failing to keep records, destroying records prematurely, obstructing an inspector, making an unauthorized disclosure, tipping off, failing to report cash transactions, suspicious transactions, electronic transfers when required. These can all be criminal offenses.
And that structuring thing you mentioned, breaking up transactions.
Yes, Section 64 makes structuring to avoid reporting duties a specific, serious offense with potentially severe penalties.
How severe? What are the general penalties?
Section 68 lays it out. For the most serious offenses, it can be imprisonment for up to 15 years, or a fine of up to R100 million.
100 million. Okay, FICA has teeth.
It certainly does. There are lesser penalties for other offenses, maybe up to 5 years or R10 million. Interestingly, Section 69 provides a potential defense for employees if they can show they were following their institution's approved RMCP, or if they reported their concerns internally to their compliance officer or superior.
So following internal procedures can offer some protection.
It can. And there's also forfeiture. Under Section 70, property connected to certain offenses, like structuring or failing to report cross-border cash movements, can be forfeited to the state.
So you could lose the assets involved too. What if an institution feels a sanction or decision against them is unfair?
There's recourse. Section 45E establishes an independent appeal board. It's staffed by members drawn from the financial sector tribunal. Institutions can appeal decisions made by the FIC or supervisory bodies to this board, providing an important check and balance.
An independent review. Good.
And beyond that, Section 45F allows the FIC or supervisory bodies to apply to the High Court to enforce compliance, stop contraventions, or get clarity on legal points.
Okay, that's a lot of detail on how FICA works. Let's bring it back to the real world. What does all this mean for businesses trying to operate and for ordinary individuals?
Right, the practical impact. For businesses, especially those defined as accountable institutions, FICA imposes significant responsibilities. It's a major compliance burden. Definitely. It means investing in robust systems, ongoing staff training, developing and maintaining that RMCP, dedicating resources to compliance functions. It's not just banks, remember, attorneys, estate agents, others, anyone who could potentially be exploited needs these controls. It's the cost of doing business in a regulated financial system.
And for us as individuals, sometimes it feels like a hassle, providing all that documentation.
It can feel that way, sure. Being asked for ID, proof of address, maybe questions about a large transaction. But fundamentally, FICA is working, often invisibly, to make the financial system safer for you.
How so?
It protects the integrity of the system you rely on. It makes it harder for criminals to profit from activities that harm society. It helps prevent the kind of financial instability that large-scale crime can cause. So that extra ID check, while maybe annoying in the moment, is part of protecting the broader economy and, indirectly, your own financial well-being.
And looking bigger picture, nationally, internationally.
FICA demonstrates South Africa's commitment to global standards in fighting financial crime. It directly connects our local efforts to international initiatives against terrorism, against the proliferation of weapons. The link to UN Security Council sanctions is a clear example of that global cooperation. It helps maintain trust in our financial system internationally.
So it's about domestic safety and international reputation.
Both, but it's always a balancing act, isn't it?
How do you mean?
Well, FICA needs to be effective against crime, but it also have to operate within the bounds of privacy and data protection. Section 41A talks about protecting personal information. Section 41 about confidentiality. There's this constant tension. How much transparency and security can we have without unduly infringing on individual privacy rights?
A difficult line to walk.
Always.
Okay, so wrapping up this deep dive. FICA, clearly not just some obscure law. It's this evolving shield, really, against money laundering, terror financing, proliferation financing.
A shield that puts a lot of responsibility on institutions, emphasizes knowing your client deeply, and relies on vigilant reporting.
Yeah, all aimed at keeping our financial system safer and more robust for everyone. Which leaves us with a thought, I suppose. As financial crime gets ever more complex, driven by technology, globalization, how much further do these kinds of measures need to go? Where does that balance between security and privacy ultimately settle? And, what's the true cost, not just financial, but maybe societal, of maintaining this constant necessary vigilance, something to chew on?